Houston, our instruments are showing that we have a incoming message from deep space. Repeat, Houston, we have an incoming message from deep space. Houston, we'll begin playing message now. Houston, we're going to try and translate that up here. Hold for translation. Translation complete. We'll begin playing message now.
Hey, it's me, Melissa.
What do you do when the aliens invade? Take a shot of MK Ultra and watch Melissa Jade. Put on your tinfoil hat and tune right in. We got that crime spree, flat earth theories, government conspiracies, a complex Mandela effects, unidentified objects of mind expanding, fake moon landing, what it all that's understanding. It's me, Melissa. It's me, Melissa. Aliens is on the sun or in Area 51. Time travels, unravels, haunted castles, cops are baffled, potential experimental thoughts that make you transcendental. It's me, Melissa. It's me, Melissa. Crime sprees, flat earth theories, government conspiracies, complex Mandela effects, unidentified objects of mind expanding, fake moon landing, what it all that's understanding. It's me, Melissa. It's me, Melissa.
Hello, everybody. Hey, Shay.
Hey, Melissa. Hey, everybody.
Happy Saturday night.
Yes.
Thank you, Trio Girl Mom, for 17 months. That's so long. Thank you so much for the support. Hey, Harlot, Midnight Lates, Mallory, MK, KPFA, J13. We have C. Kata, you too. We have Shay, not you, Shay, the other Shay. We have Watercolor Dog, Jeremy, Meat Noodle. Yes, sorry, I was eating. Jules, Gidget, Accomplice, Cerebellum, Ruffian, Fragile Like a Bomb, Medusa. Hi, everybody. Good news right off the bat is this trial is going to continue on as scheduled. Hi, Natasha. Hi, Dudley. Continued on as scheduled. What are your thoughts of that, Shay?
I'm pleased. I think that seems like the right ruling, but I'm anxious to get into the docs because I hear Judge Hippler is pretty stern in his statements.
I'm sure he will be. I'm very looking forward to it. All right, so here's our missing child. This is Terry Miller. Terry has been missing since June 14th, 2025, out of Meridian, I think it's Mississippi, right? MS is Mississippi.
Yes.
She is 18 years old. Well, all right, so again, last seen on June 14th. So if you or anyone you know has information on her whereabouts, please contact the Lauderdale County Sheriff's Office at 1-601-482-9806. Babies, she's beautiful, but look at her lips. Oh my goodness. Those are some great lips.
Oh,
Yeah.
clever glasses too.
Yeah, I do. Hi, Lisa, Andrea, Indigo. Thank you, Kelly, for 7 months plus 4 fingers. Well, thank you. The Gypshit billboard, meaning like Gypsy Rose. Gypshit? I'm assuming that's going to be Gypsy Rose, right? If so, no, I did not. What is it?
I figure like Woofy would know this. She keeps up on everything Jip.
What is the Gypshit billboard? Hold on.
Gotta look it up now.
Gypsy Rose billboard?
I don't know.
What is it? Nothing's coming up for me. I know, Harlot, 1 year. Like, I think, no, well, like a little over a year she had. What'd she do? What's the billboard?
I don't know. I didn't see anything. Whoopee.
What's the billboard? Okay, here, let me pull this up.
I am Neat Noodle. I'm sorry, I can't tag everyone right now. I'm multitasking. Hey, everybody.
Someone purchased a billboard to call her out. I'm gonna have to look into that.
Oh,
I
whoopee. Find
can't.
it.
I can't with Gypsy. She bothers me greatly. She bothers me greatly. Isn't that
Her and Casey Anthony, both
yeah?
for me.
I'm gonna
Right.
man, I'm sure it's on the TikToks. I don't navigate TikToks like that.
I see they're posted about her struggling in karaoke. That just posted on TMZ.
Uh, whew. Okay. So we have a few things to go over. Let me see. I think I guess we should start with Hitler and then move on to the alternate perpetrators.
Okie dokes.
Okay, let me see. Defendant's 24th supplemental request for discovery. Defendant's motion to seal exhibit. Amended scheduling order. No.
They're at the top. The redacteds.
Random decision. Okay.
Yeah, I know that they had like some witnesses that they were trying to see if they were gonna subpoena and bring in that people that were tied to Kohberger.
Mm-hmm. Shay, I'm so excited for the Prime series. Like, I'm really excited.
Yeah, I am too. I really am. I'm curious as well.
Hi, Missy's Angels. Hi, Kathy Joe. Me too. I'm so ready, Jules. I'm so ready. All right, let's just get right into it. So, obviously, we know Ann Taylor was asking for a postponement. And so the question was, okay, with the Dateline and the Prime series and all the books that are dropping, yes, I understand it's the cause for concern as far as getting a fair trial. But the question is, what would postponing the trial do in regards to that? Is anything going to be like, is anything going to change, or is it actually going to get worse? Other than that, because if your only argument is the publicity, so to speak, that's not going to get better. That could actually only get worse. And so the only concern I had as far as Judge Hippler granting this request was that, like I've said before, that possibility of down the road during appeals not granting at least one request can potentially be used, so. But I'm so happy that he didn't.
Yeah, I see both sides of it too.
Yeah.
I
And you
definitely
spoke
do.
a lot about the victims' families and their rights, and it's been, I don't think she made her argument solid enough for him to grant it.
I mean, it took him a week to, for them to at least post on the docket to issue this. So it sounds like, he put great thought into it.
Oh, and he did. I think he takes it very seriously. I really like Hippler.
Yeah, I do too.
Yeah, that's true. I'm just happy we got a change of venue. I don't think Anne's happy at this point because she was able to kind of dictate a lot with Judge, but not so much with Hippler. Yeah, Jeremy. Hey, Wolfie. All right, so we have the redacted memorandum, decision and order on defendant's motion to continue. So you want to start with the introduction?
Yes. Before the court is defendant's motion to continue the trial in this matter. The basis for this motion is threefold. Sorry, do you want to read that? All right.
No, everything.
First, he asserts that the volume of discovery continues to pose a challenge to his counsel's ability to timely and meaningfully review all meaningfully review all of it. Second, he asserts that there is penalty phase investigation and preparation that still needs to be done. Third, he asserts that recent and forthcoming publicity on the case is highly prejudicial. Maintaining the current trial setting under these circumstances, he argues, will render any conviction and sentence unconstitutional. The state responds that Kohberger's motion is untimely and he has failed to show either good cause for continuing the trial or prejudice that would result from maintaining the current trial setting. Oral argument on the motion was held on June 18, 2025, after which the court took the matter under advisement. The court finds a continuance is not warranted as Kohberger has not made a showing that there is good cause to continue the trial or that his substantial rights will be prejudiced by proceeding as trial scheduled. So there's standards. So the subscript to that said that Kohberger filed some of his supporting materials ex parte. While the court is not convinced that much of his filing is necessary or appropriate to be treated as ex parte, the court will nevertheless, in an abundance of caution, issue a redacted and unredacted version of this order, with the state only receiving the redacted version given that the court is denying Kohberger's motion. Just side note, Melissa, I heard that we will definitely have to read the footnotes on these because there's quite a bit that he puts out there.
Okay.
So on discretionary matters of this court, on discretionary matters, the trial court must, 1, correctly perceive the issue as one of discretion, 2, act within the outer boundaries of its discretion, 3, act consistently with the legal standards applicable to the specific choice available to it, and 4, reach its decision by the exercise of reason. I'm so glad that wasn't long.
Yeah.
All right, so the analysis. Under Idaho law, a criminal defendant seeking a continuance of trial must demonstrate that his or her substantial rights will be prejudiced absent a continuance. The burden of assembling the witnesses, lawyers, and jurors at the place and time for trial counsels against continuance acceptance, except for compelling reasons. There are no mechanical tests for deciding when a denial of a continuance is so arbitrary as to violate due process. The answer must be found in the circumstances present in every case, particularly in the reasons presented to the trial judge at the time the request is denied. Where a continuance is sought based on the late disclosure or discovery of evidence, the alleged tardiness of the discovery must be shown to so prejudice the defendant's case preparation that a fair trial will be denied. And it's quoting case law. So the bare claim that additional investigation could have been conducted is not sufficient to demonstrate unfair prejudice so as to support a motion for continuance. Scroll. Where continuance is, additionally, where continuance is sought for the potential receipt of evidence from further investigation, the motion is properly denied if based on speculation. Kohberger argues that continuance is necessary for him to sufficiently review relevant discovery, conduct a full and complete investigation of mitigation evidence, particularly claimed newly revealed evidence that allegedly raises, quote, red flags, unquote, and remedy the prejudice caused by recent and upcoming inflammatory publicity and the alleged leak of information to the media. Moving forward with the trial, he warns will violate his rights under the United States and Idaho's constitutions due to due process, to be free from cruel and unusual punishment, to a fair trial, to effective assistance of counsel, to present a defense and confront witnesses, and to a fair and reliable sentencing determination. Absent from Kohberger's materials, however, is any good cause for the continuance or legitimate showing of prejudice should the trial proceed as scheduled.
Mm-hmm.
A. Defendant has not demonstrated a continuance is warranted to review discovery. Kohberger first contends that the vast amount of discovery in the case renders it impossible for the defense team to review the necessary and relevant discovery in a manner that allows for it to comprehensively um, integrated into his defense. Go ahead.
Thank you, MK. Go
I
ahead.
thought
Thanks, MK. Why isn't my comment posing? I thanked you in the chat. There we go. Okay. Thank you.
I saw it on my phone in the corner of the eye. I was like, she's about to stop. Okay.
Yes.
He further agrees without any support or explanation that there are a myriad of issues that continue to arise from the state failing to comply with discovery and expert disclosure deadlines. A continuance, he argues, is necessary for counsel to mount an effective defense. So this subscript says that Kohberger specifically cites to the 5th, 6th, 8th, and 14th Amendments to the U.S. Constitution and Article 1 of the Idaho Constitution. Notably, Kohberger does not argue that the Idaho Constitution provides any heightened protection that the U.S. Constitution with regard to the rights cited. Thus, the court will not engage in a separate analysis under the Idaho Constitution. And also it says, can you just scroll down a little bit? Kohberger continues to complain to the state's discovery violations, but to be clear, this court has found no such violations by the state. Okay, we'll go back up just a little bit. And okay, so a continuance, he argues, is necessary for counsel to mount an effective defense. So the court, however, rejected this same argument 2 months ago when Kohberger sought to strike the death penalty and impose discovery obligations upon the state. In its order, the court observed the utter lack of any proof supporting Kohberger's accusations of discovery violations by the state. More importantly, the court found Kohberger's complaints of being unable to meaningfully review discovery entirely unconvincing, pointing out that counsel struggled to articulate in any meaningful way what evidence, let alone relevant evidence, counsel had been unable to review over the past 2+ years, and why efforts to facilitate discovery review were not made long ago through this court and or the resource judge. And the following footnotes to end this is it says see order on Kohberger's motion to strike the death penalty. And then it says Kohberger's continual reference to the number of terabytes of discovery produced in this case is not helpful without providing a meaningful explanation of what data primarily consist of and its particular relevance and importance. Indeed, as was discussed on April 9, 2025 hearing in this case, it appears that most of those terabytes consist of extensive video surveillance from local businesses and residents that show nothing of significance. In fact, the state indicated at the hearing that much of that discovery is completely irrelevant and stipulated that it is unaware of any Brady material in the video surveillance footage other than that specifically identified in motion practice. Given that the state has identified all of its trial exhibits, the defense cannot be unaware. Because of all the incriminating evidence in the discovery. Finally, it should be noted that it was Kohberger who early on demanded that the state provided all investigative materials, no matter how irrelevant or unhelpful. Ouch.
Hmm.
What do you think of that? Because I can kind of see that looking like a couple different ways. Like maybe the state feels like it's not exculpatory evidence, but the defense could feel differently. What do you think? Like when it comes to the videos,
Right. And but as far as I'm understanding, like the state, when they said there's nothing of worth, nothing,
the Brady material.
Right. There's no Brady material within it. And if there is, that they could get in serious trouble for it, and that could be used. I don't imagine that they would, but I could understand defense point of view of you may not see it the same way that I see it. And that's subjective,
Right. That's interesting. He's being very strong.
Right.
In his words. Okay. So Kohberger's second round of this argument fares no better. He again fails to identify any relevant discovery that his counsel has yet to review. He also fails to identify any steps his counsel has taken, particularly since the court's prior order, to aid in processing the yet unreviewed discovery. Moreover, he does not explain why he waited to seek a continuance until after discovery closed. Expert disclosure deadlines passed and the pretrial conference occurred. If defense counsel was truly struggling with discovery review, this motion should have been made when the claimed problem became apparent, and certainly should have been brought prior to the expiration of discovery, all expert deadlines, and the final pretrial conference. Instead, defense counsel has robustly litigated this case, retaining approximately 24 experts and a full mitigation team, engaging in extensive motion practice, and disclosing witness and exhibit lists with nary a whisper that a continuance would be sought. These actions belie his counsel's ongoing and ultimately empty discovery complaints. Shit.
Mm-hmm.
Oh my gosh. Okay. Without more, the court can only conclude the defense counsel is using the volume of discovery measured in terabytes as a tactic to delay the proceeding at the 11th hour simply for the sake of delay rather than a legitimate threat of prejudice to Kohberger's substantial rights.
Yeah.
Perhaps even more problematic and more telling is the utter failure of defense counsel now or at any time to specify not only what needs to be reviewed, but importantly, when that review would be complete and Kohberger ready for trial. Instead, Kohberger seeks an unbounded continuance with no apparent plan to complete the review of unspecified evidence that counsel claims it has yet to review. This is not sufficient to warrant a continuance. All right, let's see what they say. So these are the footnotes that from the top paragraph. So 6, the only discovery counsel claims that has not been fully reviewed are all of the thousands of tips provided to law enforcement. She argues these tips may lead to the discovery of evidence of an alternate perpetrator. The deadline for presenting alternate perpetrator evidence has come and gone, with no motion by the defense to extend it. Further, to offer alternate perpetrator evidence, Kohberger needs to far more than an substantiated hearsay tip that another person could have committed the crime. State versus Meister. 7, at the hearing on Kohberger's motion to strike the death penalty based on his counsel's alleged inability to process discovery, the court suggested several options counsel has to obtain assistance in discovery review. There is no evidence that defense counsel has exercised any of these options, nor has there been any good explanations of why counsel had not sought additional resources to process and review discovery, such as the tips and security videos. The failures to do so suggest a recognition that the discovery was extremely unlikely to bear fruit. Lastly, relevant here too is the fact that the defense counsel did not argue for a continuance as an alternate remedy to Kohberger's attempt to strike the death penalty because of counsel's alleged inability to get through the discovery. This highlights that his claims regarding the volume of discovery were used as a tactical sword, untethered to a serious, legitimate concern about the ability to be prepared. Holy shit.
Yeah, he's letting it be known. Oh, we got some redactions in here too. What were you gonna say?
No, I'm just not sure.
Yeah.
Wow.
Harlot says, I'm so glad Hitler has the case now. I can only imagine what a frustrating mess this whole thing would be if Judge was still in charge.
And I hear people who haven't followed the Kohberger case, so if you're new and you're joining, and maybe they followed the Reed case, they're like, is Hitler like Judge Beverly Cannoni? No.
No.
Totally different. Totally different than Judge Gold from Delphi. You know, they're their own. Hitler is just on the straight and narrow. He got this case transferred to his courthouse based on motions filed by the defense for change of venue, and he's kept it in order and scheduling. And he seems like he's been fair to the defense too in times. But these are tactics that we have seen through many filings and court hearings, right, Melissa?
Yes, for sure. And it makes such a big difference when you have like a really great judge, like, and I'm so
Yeah,
appreciative we have Judge Hippler on this.
I do too.
All right. So B, defendant Kohberger has not established a continuance is necessary to conduct a more thorough life history investigation and identify necessary experts because oof, Anne was holding on to this, man. She was just, I need to go back 3 generations and I need to know when he was moved from diapers to potty training to the actual urinal. It's been too much, too far, honestly. So it says Kohberger next argues that he needs additional time to investigate and prepare mitigation evidence, which he contends is necessary to uphold his constitutional rights, particularly those under the 8th and 6th Amendments. Specifically, Kohberger's team claims that to be effective counsel, he must conduct an exhaustive and comprehensive dive into Kohberger's life history for additional mitigation evidence, analyze the information into cohesive narrative for the jury, and identify any additional behavioral, cultural, scientific, and or mental health experts that may be necessary to develop the mitigation presentation. Despite having hired a mitigation team 2 years ago, defense counsel contends that recently discovered redacted have raised red flags, which I'm going to assume recently discovered traits, characteristics, something that Kohberger has exhibited in past documented events. That's just my opinion, though. So, recently discovered 2 words have raised red flags that Kohberger may have redacted. According to Kohberger's primary mitigation investigator, attorney redacted, her team of FAW have been diligent in their investigation into Kohberger's life history, but there have been redactions. She believes that with time, she will be able to overcome these barriers by redacted, ex parte, declaration, redaction, paragraph 3. So
If they have their own mitigation expert, Melissa, then I guess my question is how do they not have the time to go through the discovery?
That's a
Because
great point.
yeah, because I guess what I've understood just through just general legal analysis has been that the mitigation team can still work ongoing while a trial could be taking place.
Yes, correct. But I also like, and I know we're about to get into after this, the alternate perpetrators, but I'm very aware of how this is all unfolding and the timing that everything seems to keep unfolding within these last 6 months. It seems like when one fails, the next step is taken with now, well, this is going on now we see, like with the diagnoses, and then we see with, oh, all of a sudden I need more time, but I found an alternate perpetrator, and now I found a fall alternate perpetrator. Like, it's very interesting how the timing this is all unfolding.
Well, and I would surmise that maybe I think that kind of goes along with the theory that we saw in some of the filings of Anne getting expert like witness testimony on this crime would take more than one person.
Yeah.
So maybe trying to find a group of people that are in close relation out of some of that. I don't know.
I don't know. I guess we'll get into it when we read that next. But I'm aware because, like, well, as it gets denied, which she was aware it was going to just after the last way Hippler ended that last hearing, saying proceed as if it's on track, for August 11th. But I think now all of a sudden, like with the alternate perpetrators, it's very interesting.
Yeah.
So it says Kohberger has not demonstrated a continuance to accommodate further investigation is constitutionally required. The 8th Amendment requires that a capital defendant be allowed to present all relevant evidence in mitigation. In addition, a capital defendant has a 6th Amendment right to a fair trial and effective assistance of counsel in both the guilt and penalty phases of a capital case. As defendant points out, defense counsel is constitutionally required to conduct a thorough investigation in preparation for the penalty phase of a capital case. Presentation of some mitigating evidence, even if strong, is insufficient if other mitigating evidence is available upon reasonable investigation. The assertion that counsel needs the continuance to conduct an exhaustive and comprehensive dive into Kohberger's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. Counsel's investigation into mitigation evidence must be reasonable. The Idaho Supreme Court and the United States Supreme Court hold that defense counsel is not required to investigate a defendant's entire life in order to present constitutionally sufficient mitigation evidence. And this is what we heard Josh use in his argument during the hearing. Then it cites case law, and it says, while Kohberger notes that the ABA guidelines for mitigation function of defense teams in death penalty cases urge counsel in death penalty cases to conduct an ongoing, exhaustive, and independent investigation of every aspect of the client's character, history, records, or any circumstances of the offense to meet their constitutional obligations, courts look not to what is prudent or appropriate, but only what is constitutionally compelled. So Roe, a capital case, is instructive here. On post-conviction, Roe argued her counsel was deficient because they failed to perform an adequate investigation into Roe's background in search of mitigating evidence. Specifically, Roe argued counsel should have investigated her life from birth to the sentencing hearing, that counsel were deficient in presenting her mental health workup. The court rejected this claim, holding that counsel was not required to investigate Roe's entire life in order to objectively and reasonably present Roe's mitigation evidence. The court further noted that great lengths counsel underwent to investigate and present mitigating evidence from several of Roe's friends' health welfare records, letter from friends and family, and Veterans Administration records concerning Roe's husband's previous injuries and the couple's relationships. So, although the state points out Idaho Supreme Court has declined the invitation to adopt these guidelines, Idaho Public Defender statutes adopted in 2023 requires the state public defender to implement the ABA guidelines for defendants' attorneys delivering indigent defense services. So it's recognized that ABA are guides to determining what is reasonable. Behind the general requirement of reasonableness, specific guidelines are not appropriate. In other words, the ABA guidelines are not dogmatic code. They are simply roadmaps to aid counsel in complying with their obligations of representation.
Interesting. He backs that. Okay, good.
Yes, he does.
Oh, wow. There's a list.
Yeah, that's, yep. Then
I like list.
Yeah. So it says the investigation Kohberger's experts have undertaken over the past 2+ years far exceeds that in Roe, and in fact readily appears to satisfy the relevant ABA guidelines cited by Kohberger. It includes, but it's not limited to, Kohberger's KPhD education records, including coursework, interviews, and correspondence. Kohberger's mental health and medical records, including records related to a childhood car accident, Kohberger's employment records, mental health, education, and employment records of Kohberger's sisters, mental health records of Kohberger's parents, his dad's military records and Social Security records, court records from multiple generations of Kohberger family on the paternal side, VA records and death certificates from maternal and paternal uncles, multiple interviews with Kohberger and each immediate family member, interview of 2 of Kohberger's 4th grade teachers, former boxing coach, and psychologist who evaluated Kohberger in 2005, over 20 years ago. Interviews with multiple members of Kohberger's extended family on maternal and paternal side. Interview with Kohberger's professor and advisor at DeSales University. Interviews of Kohberger's former coworker. Interview of at least one family friend, and letters and jail calls between Kohberger and his family. It says these topics of investigation were obtained from Kohberger's disclosed penalty phase expert reports, and in its opposition to Kohberger's current motion, the state appended 2 labels that that cross-reference the list of tasks Kohberger has identified from the ABA guidelines with the actual record in this case. These tables demonstrate that the guidelines have been amply satisfied, and I do think the state did a great job with those. It says it is evident from the reports of Kohberger's mitigation experts, Dr. Orr, Dr. Ryan, and Dr. Brahms, that they have developed an expansive understanding of Kohberger's family environment, social development history, family history, both nuclear and extended over multiple generations, educational history and mental health history, and medical history. From this evidence, these experts have rendered several current diagnoses and identified other diagnoses from which defendant met criteria at some point in his life. Despite such an extensive investigation, Kohberger claims additional investigation is wanted to identify 1, redacted, and 2, redacted. However, Kohberger has not established that such investigation is constitutionally compelled, particularly given the extensive work already completed. Rather, the claimed need is based on unqualified speculation by, someone. Kohberger has not offered any declaration by any of his disclosed mitigation experts opining the same, nor has he pointed to anything in their expert reports that would support someone's speculation. As noted, a continuance of trial is not warranted to chase down mere speculation that potential evidence exists. Further, Kohberger has not set forth a plan for continued investigation, how much time it will take, what his team expects the investigation will reveal, why it is necessary to uphold its constitutional rights, and why these matters are only now being raised with the court. Additionally, assuming guilt is found, the penalty phase of the case will not begin until late October or early November. Thus, there remains significant time for Redacted and her team to continue their investigation and to supplement expert disclosures if warranted. 1, redacted speculation that Kohberger's redacted is simply that, speculation built on circumstantial evidence. Redacted conditions which are currently attributed by his own mitigation experts to his OCD, and or ADHD are consistent with childhood trauma. And 5, there is evidence of poverty, both generation and familial. Help me, I'm poor. What does that mean? According to Redacted.
I don't know, but I will say I think the defense has done a really good job of researching these materials for Kohberger. I do want to note that.
I will say absolutely, but you know what stands out to me? You are focusing on a lot about that because you can't focus on the evidence against him. You know what I mean? You are focusing more on, he's going to be found guilty. So what are we going to use as a mitigating factor to get him off the death penalty?
Well, I think you got to, think 10 steps ahead, and definitely for the mitigation, experts, this stuff is important. But I get, and going back to the need of continuance based on not being able to review discovery, it just, that kind of falls short for me because I agree there's been ample time to file this with the court, especially when some of that discovery and those largest amounts of terabytes that we know of was produced early on.
Right. Oh, man.
But no, I agree with you. I just still reading that. Like, it seems like they have done a good job of researching for his mitigation. Like, I have to give props for this zealous defense. I think that's good.
Matt says, yeah, it's funny, but circumstantial evidence isn't going to convict this dude if quadruple murder, just so all you funny people know. Ha ha. First of all, do you know majority of murder cases are surmised of circumstantial evidence? Do you know what isn't considered circumstantial evidence? Seriously, not even being a dick. Are you aware of what would be considered not circumstantial evidence? Because I don't like when people say it's all circumstantial. Most cases are circumstantial evidence.
Right.
Okay, if you say then like this here's what I'll say, Matt. We don't know what evidence is against him because we haven't got to trial yet. So to sit here and act like, well, we know what all the evidence is against him, he's innocent. Well, no, you shouldn't be thinking he's innocent or guilty 100% until we watch what the evidence is presented against him in court. But with that being said, you have no idea what they have or what they don't have. You just are focusing on the one thing that, hey, we all acknowledge that's pretty damn impressive. But you have to realize 6 weeks passed before they arrested Kohberger. Okay, there was time that was passed. But if he isn't the guy, if he isn't guilty, then you have nothing to worry about because the evidence won't show he is guilty, right?
I mean,
It's not as simple as that.
the jury is the trier of facts. We're just reading the court documents, so chill out. Not to
Who
you.
blocks you? Nobody blocks in my chat, so I know the hell you ain't talking about me.
No, he's been timed out before. There's
a difference.
He comes in here with agitating comments.
If you've been timed out, that means you have to be really persistent and annoying. But you never got blocked. Don't say you got blocked. We don't really block here.
You have like the lowest block list ever.
Yeah, I have the same block list I've had pretty much. No, see, all the time you only get blocked once, you dumbass. Sorry, I'm gonna say you dumbass because if you're coming in here talking about damn evidence in a quadruple murder case, yet you don't even know what the definition of blocked. You can't be blocked all the time, dude. You get blocked once. Like it's as simple as that. Come on. It was the calling you a bitch that got him timed out. See, well then that's that. That's a timing out though. It's not I get blocked all the time. Well, you only get blocked one time and then you're out. But okay. That's your right. That's your opinion. But again, if he's not guilty, don't worry about it. The evidence won't be against him. It's simple as that. See, I think she is prepared for trial, but there's a difference between being prepared and having the weight of evidence in your favor. And I don't think she has the weight of evidence in her favor. You know what I mean?
Yeah. I mean, of course. Like they say, like they always could have more time to find more reasonable doubt. And I think that we haven't gotten into the other documents, but if there was a reason that I feel like the court could weigh that they needed to give the defense time to do more research that would prejudice the client, they would definitely put Bryan's rights above that.
Yeah.
And I mean, everything is going to be saved for appeals too. So,
but what does that mean? People like me. Show us on the doll where the book hurt you. Okay. Oh man. Okay. It says according to redactions. And sorry, I want to jump 14.
You didn't have any footnotes. I checked them along the way.
Okay.
You didn't have much. They were just noting prior things that were redacted.
No, I know, but it's all redacted, man. So the whole paragraph's redacted, and it says notably missing from redacted declaration is any indication. I want to know who that is, Shay. Any indication as to how she intends to confirm her suspicions or how long she expects it to take, be that months, years, or even decades. Kohberger has been subjected to multiple lengthy interviews by several different experts over the past 2 years. Based on the expert reports reviewed by this court, redacted. Oh, it's not going to be in his favor, Shay. Kohberger's family has likewise been extensively interviewed, and there has been no report that redacted. None of Kohberger's redactions have raised the alarm that redaction, despite having the same information redacted relies upon. A bunch of redactions.
This could be experts, maybe doctors, I'm assuming.
It's one specifically.
Okay. This is just me surmising.
Yeah, it appears that it's one female specifically, expert, who is trying to find proof that something happened and or Kohberger has something and hasn't been able to. But court is explaining right now, there has been nothing in all of the extensive interviews, evaluations, mental health experts that shows that. So is it going to take weeks, months, years, or even decades to find what this person is looking for? It's mere speculation, which I'm really curious. What is she claiming? Sexual abuse? Is she claiming a history of some type of specific mental illness? Like, what are you focusing on?
Yeah, that is interesting. At first, I was wondering if it's a family member, but a sentence right below on page 9 said defendant's families likewise been extensively interviewed. So that makes you think it's not a family member. It's probably a professional.
No, it would be an expert.
Right.
But what they're claiming, it would be pure speculation. It's not based on anything tangible. So it says, instead, it is an invitation for a perpetual continuance. More importantly, aside from the redaction, all of this information has been available and documented in the record for months. Yet again, that Kohberger is only now moving for a continuance for further investigation into, what's that word? Unsupported suspicion smacks of tactical gamesmanship and delay. Oh, absent more compelling evidence that redactions plan for redaction. It is unreasonable for the court to continue the trial indefinitely for redacted, a plan that is temporally unbounded, substantively undefined, and unlikely to result in any relevant mitigation evidence in the foreseeable future. Uncovering it and a reasonable timeline to do so, there is no constitutional basis for further investigation, particularly on an open-ended basis with no plan to bring the matter home. He is letting it be known.
Interesting.
Okay. Oh, man. Yeah, it's very interesting, but I want to know, what expert did they bring on and what did they submit that Hippler's like, nah, man, like, what are you even doing? And that's not even based in reality.
Yeah, I'm curious because it said even the defendant's family interview. So you would think that if it was something that, his family could help connect and provide, they would. So I'm very curious.
Samantha says, I thought he would just deny their motion to delay the trial. I wasn't expecting him to also serve it with a bunch of sass. Yeah. They do have to explain their reasoning, but it's lovely.
Yeah, and you definitely, especially for the court, they need to do that for appeals process too. They need to back it in their findings in case law.
And he backed it. He fucking backed it all right. You can read.
Okay. Redacted. Counsel's argument that more time is needed to investigate whether redacted, likewise squarely unsupported. Redacted. Defendant has never moved for an extension to his disclosure deadline for penalty phase experts so as to allow further opinions in this regard. Nevertheless, redacted, who again is not even marginally qualified to, oh my lord, qualified to opine, blank, believes that there is evidence that, redacted, and seeks additional time to unearth it. For support which she has not provided to the court, redacted. Again, not one of Kohberger's redacted experts who have had the same information redacted has submitted a declaration stating that they may change their diagnoses based on further investigation, redacted. Wow. Interesting. Rather, it is based on redacted speculation that further investigation might change redacted. Such speculation is not grounds for continuance redactions.
Interesting. She's pulling out all the stops, but again, realize it's all focused on the penalty phase.
But what would get them out of the penalty phase? Because they said that if he has like he doesn't have the lower IQ in what we would probably perceive more in the Atkins, right? Because they
Right.
said Atkins was lower IQ. You
Yep.
couldn't just say because he had autism. So I'm really interested where they're
I don't
going with
think that
this.
this was the ASD. I think that this is speculation that
Something like horrific happened to him.
some type of
I don't know. I don't.
it's obvious what category it's in, but at this, it could be a couple of different things, but it's good to know none of that exists. This is pure speculation, and even out of all of the evidence and extensive mental health experts looking in and the evaluations, all of the reports, there's nothing that even indicates that. So it's pure speculation. And hey, give me an unlimited amount of time to basically find what I want to look for. That's like me speculating, Shay, that like you had gotten into a car accident. I'm basing that off of nothing. And then I need to take as much time as I need, like to find that. Like, it's where are you basing it off of though? Like, what did you hear on an art, like on the news that there was a car accident that involved you? Did you, like, where is it coming from?
And I heard something about him being in a childhood car accident.
Yeah, they mentioned that.
Right.
They mentioned it.
Okay, we're going down to page 12.
A bunch of redactions.
Right. Not only is there a lack of support in the record for redaction, anticipation that more investigation into redacted to change their minds, redacted and her team and defense counsel have known since November of 2024 that redacted. Neither the defense team nor redacted have articulated what efforts they have made, if any, since that time to understand the basis of redacted. Further, they have not indicated what plan they have to obtain this information if a continuance is granted or how long it will take. Redacted.
It has to be a mental health thing. Like, it has to be something, like something.
Yeah.
Because it's one word and he's saying to prove redacted. I can't imagine that being an event from the past versus something that Kohberger struggles with.
What was it that Tisha tried to claim she had?
DID, dissociative identity disorder.
Do you think that could be
it came in my mind? It definitely came in my mind because, again, if it was an event, I think it would be, I wouldn't expect Hitler to say, like, there's nothing that it's even based on, because you could surmise that something happened from an event that you can prove occurred, like the car accident, versus if they're looking for something that they are claiming Kohberger struggles with as a mitigation factor in the death penalty phase, that I can imagine they're struggling to find something that they could correlate it to in the interviews and medical records and school records. They're digging and looking and they haven't found it yet. So it would be based on pure speculation and not facts.
The only thing I think of as well, Melissa, is like, the evolving of technology and medical records. Like, could they be looking for something so far back that isn't electronic, or maybe that physician isn't around anymore? I don't know. I'm just curious.
No, I think they're going off of, listen, I think Anne knows damn well her client is guilty, and she knows damn well she's not going to be able to prove he isn't. And all of her focus and attention is going on the penalty phase. How can I show that he wasn't in his right mind, or he's not, he didn't know right from wrong because of X, Y, and Z?
Yeah.
Even though they don't have the NGRI, but that's not what but I think she's going in that NGRI aspect of things for the death penalty. She is more focused on the death penalty.
Mm-hmm.
Something, right. Samantha, something. Yeah, they need Dr. Dorothy Lewis, yo.
But you're not allowed to say those words, Samantha. You've
Yeah.
seen the
No,
motions
that's-
eliminate.
yep.
Okay. In some, Kohberger has not demonstrated that a continuance for further investigation into potential mitigation evidence is necessary to uphold his constitutional rights. The right to present mitigation evidence and the right to effective assistance of counsel do not necessitate an investigation of his entire history. They simply require that the investigation be reasonable. While easily available mitigation evidence cannot be ignored, Kohberger's briefing demonstrates that the evidence they are attempted to obtain is far from easily available and, in fact, may not even exist. Interesting. It may not even exist. Okay. So, further, the evidence prompting the need for further investigation has been available for months, yet it is only now that Kohberger seeks a continuance. This tactic seems geared toward achieving delay rather than a good faith effort to obtain meaningful mitigation evidence.
Mm.
Moreover, Kohberger provides absolutely no plan for how further investigation will proceed, who will be interviewed, or how long it will take. The Constitution does not demand, and this court is not willing to continue the trial indefinitely to allow the defense team to embark on a fishing expedition.
Yep.
Pulling it, pulling at every conceivable thread in Kohberger's family tapestry. Counsel's assertion that they will be better prepared with more time and more evidence is an assertion shared by every lawyer involved in a trial. That's true. At some point, and particularly after 2.5 years of an investigation, the defense team must be satisfied with what they have, which in this case is extensive. In addition, while the crime victim's rights to a timely disposition under Article 1, Section 22 of the Idaho Constitution, Idaho Code 19, do not trump Kohberger's federal constitution rights, they provide an additional justification for proceeding with trial as scheduled for these reasons. A continuance is not warranted.
Mm-hmm.
So I'm going to read the subscripts because we don't have any on this C real quick. So it says so subscript 19, however, this does not mean that this investigation into mitigation evidence has been unreasonable. It simply means that the investigation as it regards blank or redacted did not bear all the fruit redacted or defense counsel speculated it might bear. Further, redacted has provided no basis to believe that redacted with more time or that they may be the source of yet uncovered mitigation evidence. And the last is just federal constitutional laws, which, okay. So C, a continuance is not warranted due to pretrial publicity. Kohberger next seeks a continuance due to recent inflammatory pretrial publicity. On May 9, 2025, approximately 3 months before trial is set to begin, Dateline NBC aired a 2-hour episode about this case. The episode included details and materials about the case, which, if true, are not publicly available and which promote a narrative of guilt. Kohberger also advises that on July 9, 2025, Amazon Prime Video is planning to release a 4-part docuseries about the homicides, and on July 14, 2025, crime author James Patterson is set to release a book he wrote about the same, which we both know that the book that Patterson wrote was adapted into this docuseries by Prime.
Mm-hmm.
So Kohberger contends that this media coverage so close to trial threatens his right to a fair trial by an impartial jury, which can only be ameliorated. Is that right? Ameliorated. That is a new word for me.
Only be wait, where is it?
Right.
Oh.
It's ameliorate, which can only be ameliorated.
Ameliorated. Yeah, that's a new one.
Okay, by continuance. In addition, Kohberger argues that a continuance is necessary to investigate the source of the leaks to the media and impose accountability. The court does not agree that either argument compels a continuance. Okay, that's interesting.
Mm-hmm.
I don't know if I fully agree with that, though. Like, I get the part where, like, you can't stop media from talking about it, but what if those certain sources are people that are key witnesses in this case, you know?
Because it still doesn't impact his trial. They could still be a witness, and then it's a parallel. I feel like WSU Mom Kim parallel crime. Like it's a parallel issue that'll be handled outside. They, even if you find out it's one of the detectives, they still have to get up on that stand and they'll still be under oath. Now whether or not you want to try to trash their credibility by saying, hey, were you the leak? And they say no, and then they are. But either way, it's a separate issue. The same way that Ann Taylor can kind of go back and forth and be held in contempt of court for not respecting what the court order is, but she could still be the attorney in the room. You know what I mean?
Yeah, but how can she cross-examine that? Like, if she doesn't potentially know who that is, like, what if, say, he is proven
How does
guilty?
it
This
affect the evidence
investigation,
that he's going to be testifying to? He or she will be testifying to.
would that not be Brady leaking it? Sorry, I know I might be going down a rabbit hole, but I kind of see this going a couple different ways.
If they're like, again, whether or not it's a Brady issue, it's a parallel issue that it doesn't necessarily. I don't know. I
mean,
know.
I get what you're saying, because you don't want it to turn into like a secondary and, like, I don't know, trial within a trial. But
Right.
I feel like not knowing that, and say they do find out who it is, I mean, she could use that to her advantage on appeal.
Yeah, absolutely.
Okay. So Kohberger's rights to a fair trial is not denied by pretrial publicity, which is not likely to subside with time. The Sixth Amendment to the U.S. Constitution affords all criminal defendants the fundamental right to a fair trial. This includes the right to have impartial jurors who know as little as possible of the case, decide the defendant's guilt based on material admitted into evidence before them in a court proceeding, uninfluenced by extrajudicial statements. A trial judge has an affirmative duty to minimize the effects of pretrial publicity. In Shepard versus Maxwell, Shepard relied upon in Shepard relied upon by Kohberger, the United States by the defendant, the United States Supreme Court recognized the adverse effect inflammatory publicity has on the ability to obtain an impartial jury, and strongly urged trial courts to act quickly and forcefully in addressing such publicity. The court further advised that where there is a reasonable likelihood that a prejudicial news prior to trial will prevent a fair trial, the judge should continue the case until the threat abates or transfer it to another county not so permeated with publicity. This statement from Shepard, however, must be read in context. The media coverage in that case is far different from that present here. In Shepard, news reporters extensively covered the story of Sam Shepard, who was accused of bludgeoning his pregnant wife to death. The court examined the extensive media fanfare surrounding the case, noting that Shepard was not granted a change of venue to a locale away from where the publicity originated, nor was his jury sequestered. For months, the virulent publicity about Shepard and the murder had made the case notorious. Charges and countercharges were aired in the news media besides those for which Shepard was called to trial. In addition, only 3 months before trial, Shepard was examined for more than 5 hours without counsel during a 3-day inquest, which ended in a public brawl. The inquest was televised live from a high school gymnasium seating hundreds of people. Furthermore, the trial began 2 weeks before a hotly contested election at which both Chief Prosecutor Mahan and Judge Blythen were candidates for judgeships. The court found that there was no doubt this deluge of publicity reached at least some of the jury, given that when the jury was questioned for the only time, 2 jurors admitted in open court to hearing the high inflammatory charge that a prison inmate claimed Shepard was the father of her illegitimate child. Nevertheless, the trial judge rejected requests by defense counsel for the jurors to be asked whether they had read or heard specific prejudicial comment about the case. Further, the jurors were subjected to newspaper, radio, and television coverage of the trial while not taking part of the proceedings, and were allowed to go their separate ways outside the courtroom without adequate directions not to read or listen to anything concerning the case. The judge gave suggestions and requests to the jurors at intervals during the trial to refrain from commenting upon the case, but the jurors were thrust into the role of celebrities by the judge's failure to insulate them from reporters and photographers. The court reversed Shepard's murder conviction. Crucially, the court stated that although pretrial publicity alone was not sufficient to warrant relief, when combined with the carnival atmosphere the press created at trial and the judge's inability or lack of desire to control courtroom proceedings, Shepard's right to a fair trial was denied. If months of violent pretrial media coverage was not enough to deny due process in Shepard, it is certainly not enough in this case, where the media coverage has been far less pervasive. In addition, this court is employing the measures recommended in Shepard to protect a defendant from judicial pretrial publicity, to wit, 1, limiting the number of reporters in the courtroom during trial, 2, insulating prospective witnesses from interviews with the media about their prospective testimony, and 3, making an effort to control the release of leads, information, and gossip to the press by police officers, witnesses, and the counsel for both sides, to avoid the disclosure of inaccurate and or inadmissible information to the public. Ultimately, whether Kohberger can receive a fair trial depends on whether a fair and impartial jury can be seated, as the United Supreme Court has said. And I'm just going to keep going to the next paragraph. So accordingly, the Idaho Supreme Court has long recognized that trial courts can successfully select an impartial jury despite widespread publicity. So they are referencing a few different state cases, if you guys want to go back and read that. So I'm going to go down to with the measures, the next paragraph. Sorry, I know the Shepard one was really long, but I think that's probably the most important because it being federal, you know. With the measures that court has already put in place to protect Kohberger against the pretrial media coverage and the court's carefully crafted jury selection process, there is no reason to think that an impartial jury cannot be selected through a searching and robust voir dire. In addition, while continuances may be appropriate if pretrial scrutiny is reasonably expected to fade with time, it is an ineffective tool where publicity is such that there is no reason to anticipate that it would subside by any delay, which would not put off the trial indefinitely. And then it's quoting more case law. So it says, the court observed that the Sixth Amendment's guarantee of a speedy trial is one to which the government and society, as well as the accused, has a claim, and stated that society cannot be utterly deprived of the right to prosecute and try someone for a crime within a reasonable time merely because of widespread community knowledge. The footnote here says, in his reply, Kohberger argues that the allotted time is not sufficient for voir dire given the vast media coverage. The court recognizes that more time may be needed and has built in additional days for voir dire for this process or for this purpose, which I think we saw they pushed the trial back a week to allow for this. I'm going to go to the next paragraph where it says, here there is no assurance that the pretrial publicity will fade with time. The murders occurred over 2.5 years ago. The circumstances of the murders were provocative. 4 college students in a small Idaho college town were brutally stabbed to death by an unknown perpetrator. It was an immediate media sensation and garnered widespread attention that not only continues to persist, but continues to grow. 18 months ago, Kohberger moved for a change of venue from Latah County due in part of the extensive inflammatory pretrial publicity and allegations made about Mr. Kohberger to the public by media that will be inadmissible at trial. Says for change of venue, that was on January 30th, 2024, they argued that Latah County was not large enough to avoid the bias caused by the pervasive prejudicial publicity. Kohberger's motion was granted, and as a result, the trial date was continued by approximately 10 weeks. Those additional 10 weeks have not resulted in fading media attention. It has only given the media more time and opportunity to provide coverage to a public audience which is clamoring for answers. The longer the public is made to sit and wait for the facts to come out at trial, the more time there is for inflammatory speculative stories, movies, and books to circulate, and more time for prior ones to be rebroadcast, purchased, viewed, and consumed by the public. Proceeding with trial as scheduled will likely avoid negative consequences from future publicity. Thus, the court finds a continuance is not warranted based on the media coverage. Rather, careful and patient voir dire is prescribed. So two, a continuance is not warranted. Whew, sorry, guys. Two, a continuance is not warranted to investigate the leak of information. Okay, Melissa, you might want to do this one if you want. I think this is probably where it's going to get a little heated.
Yeah, it's about to be done, but it says a
Oh, okay,
continuance.
I'll do it.
Yeah, go ahead. Finish it out.
Okay.
You're so close.
Sorry. I just thought this may be one you might want to yell at. I don't know. I don't have the Melissa loudness, but I am loud. Okay. A continuance is not warranted to investigate the leak of information. Kohberger also asserts that a continuance is necessary to accommodate the special prosecutor's investigation into the source of the leaks to the media and impose accountability. With regard to the Dateline episode, Kohberger points out that Dateline represented that the material came from sources close to the investigation. Guys, we hear that all the time, though. We really do. But this one particularly, I understand. He notes that Patterson's upcoming book on the crime promises claims to be the most comprehensive narrative of the investigation and evidence to date and is based on over 300 interviews, several individuals, including the victims' families and local law enforcement. He also notes that the Amazon Prime docuseries promises to be told in captivating tense and emotionally wrenching detail by only those involved in and affected by the crime. He argues that if any of the leaks came from witnesses the state intends to call or from others involved in the investigation. I knew it. Okay, sorry. I was like, I thought this was it. The information is Brady material because it would serve to impeach the leaker's credibility and may be exculpatory in nature. He adds that if the investigation reveals that the other state agents had information about the leaks but failed to disclose it, this omission would constitute a Brady violation.
So let's see what his response is. We'll get some clarity.
Yeah. Okay. So, guys, just so y'all know, the subnotes just link the books. We'll wait to get to 26 in this paragraph to read the footnote. So, as noted, a continuance is not warranted where the information sought thereby is mere speculation. Row. At two, defendants or Kohberger's Brady argument is built on a house of speculative assumptions. An assumption that there was a leak by persons bound by the non-dissemination order. An assumption the leakers will be found. An assumption that the leakers were law enforcement. An assumption that the leakers or others who may be were complicit will be testifying as a government witness. And an assumption that these witnesses will likely be material. Such assumptions are not grounds for continuance. Particularly interesting. Okay. Particularly, I haven't read the files yet. Okay. So, particularly given that there is no guarantee if and when they will be confirmed or debunked. This trial cannot be held hostage indefinitely to the outcome of the investigation, particularly given the very significant chance the leakers may never be disclosed. Thus, the court will not continue the trial pending the result of an investigation based on the speculation that it will be successful and the hope that impeachment evidence may be uncovered as a result. And so the footnote says, while the court observed in its document and records hold order, May 15, 2025, that it appeared likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order, it could have been someone from the defense team or someone not subject to the non-dissemination order.
Yep.
The court has not made and was not, by this statement, making a finding or otherwise accusing law enforcement or the prosecution of such. Interesting. Okay. So the final order is based on the foregoing. Kohberger's motion to continue is denied. And then there's another footnote at the very bottom, says 27. In addition, even assuming if law enforcement who leaked the information, the FBI played a prominent role in the investigation of this case, if the leaks were from the FBI, a state court's ability to further investigate is highly circumscribed and limited, if not altogether foreclosed. In addition, law enforcement in Pennsylvania and Washington may have had formal and informal access to some of the evidence. Yet an Idaho state court may have significant limitations on the ability to investigate them. Wow. So they're saying they might not even be able to find out who it is. Like they might not
That's
even have
really
the
interesting.
jurisdiction.
Yeah.
That is. This is why I love the footnotes. I mean, sometimes like they're just, but Hippler seems to really put all his stuff in there.
He does. Shay, give me 1 second. I'm just running.
No, you're fine. I mean, I guess I think the part I don't know about chat, but like I was thinking that it would be more Brady if they can't find out who it is, but I mean, at the same time, I mean, the defense, you just can you put a 1 in chat if you think that the leak came from the defense team, a 2 in chat if you think it came from the FBI, or 3 if you think it came from the prosecution. I'm so curious of what chat thinks. So 1, defense team leak, 2, FBI, 3, prosecution. Interesting. Okay, Missy's the 2. I think the FBI thing is really interesting. Defense. Okay. No idea. Yeah, I mean, no, I don't. I have no idea either. Someone else. Interesting, Angel D. A local. Okay, Tracy. Yeah, 4 if you don't know. If you just think it's someone else.
I'm not sold on who I think.
Yeah, that's true. So there's that. I think there could be, multiple, but some of that information, like that we were seeing, that Dateline put up of Brian's Amazon records. I mean, I was stunned. Stunned. That made me think that's somebody who had access to materials based on those warrants. Oh, Angel D.
Yeah, it could have been. It could have been. C. Carter. She asked, "Who do you, in your opinion, think?"
Oh,
could have been
I
the
said.
leak?
Okay, sorry. I said. So I said 1 was if you think it was the defense that leaked, 2 if you thought it was FBI, 3 if you thought it was prosecution, or 4 for unknown.
Tracy, do you think a local cop would have the level of information? But Hibbler's right. It could be someone in enforcement that isn't bound by the gag order.
I mean, Missy's Angels, you're not
No.
wrong. I mean, it's a good point. I could.
What things, Angel D? You you can't just keep that from us. I wouldn't consider Moscow the prosecution, no.
I mean, I guess, you would hope that neither anybody in part of the court would release that type of information because of the severity of it, makes you wonder, did somebody leave their position of duty that had access to this stuff, or a clerk of some sort? It's really interesting.
Right. Well, I'm super excited for this one because now we got the redacted order of Kohberger's offer of proof regarding alternate perpetrators. Are you guys ready for this? Because I'm ready for this. I haven't read it. I'm so excited.
Oh, I'm totally ready. I am going to listen to you and I'm going to grab my energy drink.
Okay. You guys ready? Woo! This better be better than the alibi. All right. Introduction. The state previously moved in limine seeking to preclude Kohberger from offering or arguing alternative perpetrator evidence without first satisfying the applicable evidentiary standards. No shit. Oh, okay. In accordance with the court's subsequent order on the motion, Kohberger filed his offers of proof and evidence in support. identifying 4 individuals as potential alternate perpetrators. The state objects to the presentation of this evidence at trial, arguing it fails to satisfy the standard under State v. Meister. Kohberger conceded at oral argument that at this point, his proffer is not sufficient to pursue an alternate perpetrator theory at the outset of trial, but requests latitude in cross-examination of the state's witnesses to try and establish additional evidence to satisfy the Meister standard. Note, so just like the alibi, okay, I can't meet the standard on my own. So during cross-examination of state's witnesses, I might be able to get them to say something that'll open the door for me to what? Point the finger at them? What are you going to do? 4, is that going to be Dylan, Bethany, Jack? I'm sorry, not Jack. Dylan, Bethany, Hunter, and maybe Emily? Is that Jack? What 4?
I think that by them getting to ask investigators is them, just ensuring like, did you fully investigate this properly, and seeing through that cross-examination if they're able to develop enough information for the court to later decide if they can bring in the alternate perpetrator defense.
See, it didn't say of state's expert witnesses. It's saying state's I'm feeling like that's more the kids. And when I say the kids, I know adults, but like I see them as kids. I think that she's gonna okay, slippery slope.
So you think that they're gonna target some of the friends as alternate perpetrators?
I think not necessarily that it's going to point to them, but I think she's going to push on them and hope. I think law enforcement knows better. And so, yes, of course, I think that she's going to try to get information regarding the investigation through questioning, cross-examining law enforcement and officials. But I think it's more so pushing on the young adults.
Wow. And I agree, Missy's Angels, but I think it could happen. But the defense also has to, I think, considerably tread lightly, because I mean they're going to they don't want to lose the jury,
Right.
Like I think it's a delicate line on who you throw some of that shade at. And
It
all
is.
those good.
But to get 4 alternate, are the all 4 together, or are you just? I highly doubt it's like, oh yeah, no, I have 4 alternate perpetrators that aren't linked to one another. They'd have to be linked, Shay. You know what I mean? If you're going to come in with an alternate perpetrator or perpetrators, it's not going to be 4 unlinked possibilities. It'll be 4 overlapping in like a bigger scheme possibility. Does that make sense? In my opinion. She's not going to come in and say, well, hey, there's 4 possibilities without giving any strong evidence that points to any one of them, versus I take this as an involvement of 4.
I won't say anything because I did listen to Bryan on Twitter. I think one of the alternate perpetrators is non-relation to the other 3. I'll just so you know that.
One is, so the other 3 are?
They may have relations. I think they're the ones who actually, he never, like, all I understood was like they are people that associated with the victims, whereas one of the alternate perpetrators wasn't an association. It was, I'll just say it because we'll get to it. Remember, they said like Kaylee was like getting stalked, and it was like some guy wanting to come out and ask for her number and never did.
Yeah.
That's one of them, apparently. That's all. So the others, I don't know names. There's not names listed. I think that's just all I heard was that there was 4 and that there's 3 that knew the victims and 1 that didn't. And then they kind of brought up that thing with Kaylee.
Okay. Okay.
But
It
I don't
says-
know any. I don't know any more, Melissa. So I'm
Yeah.
just they'll be new to me too.
Okay. Well, that would still kind of align with my thinking of 3 over and
The
then
group.
1 not. Yeah. It's
The
it's
group.
grouping. Yeah, it's grouping that numerous people had knowledge. Even the knowledge could fall in. I'm curious. I'm very curious where she's going with this. So it says the court concludes that at this time, Kohberger's alternate perpetrator proffer is inadmissible under Meister as it's irrelevant and or excluded by IRE 403. However, this does not foreclose Kohberger from cross-examining law enforcement regarding the reasonableness of its investigation and its follow-up on plausible leads. So the standard trial courts have broad discretion in the admission of evidence at trial. A trial court acts within the bounds of its discretion when it's 1, correctly perceived the issue as one of discretion, and 2, acted within the outer boundaries of its discretion, 3, acted consistently with the legal standards applicable to the specific choices available to it, and 4, reached its decision by the exercise of reason. Analysis: the seminal Idaho case on the admissibility of alternative perpetrator evidence in Meister is a defendant wishing to present such evidence at trial had to first present proof of connection with the crime, such a train of facts of circumstances as tend clearly to point out someone besides the accused as the guilty party. Remote acts disconnected and outside of the crime itself cannot be separately proved for such a purpose. Meister clarified that the Idaho rules of evidence, rather than the more onerous Larson standard, control alternative perpetrator evidence admissibility. Under these rules, evidence is evident if it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without the evidence. Idaho Rule of Evidence 403 governs the exclusion of relevant evidence and permits a court to exclude evidence if its probative value is substantially outweighed by a danger of unfair prejudice, confusing the issues, misleading the jury, undue delay, wasting time, or needlessly presenting cumulative evidence. So Meister further offered the following guidance. Okay. So here, the defendant Kohberger has offered purporting to establish the 4 individuals as alternate perpetrators objectively fails to meet the Meister standard. Namely, the evidence is entirely irrelevant. Nothing links these individuals to the homicide or otherwise gives rise to a reasonable inference that they committed the crime. Indeed, it would take nothing short of rank speculation by the jury to make such a finding. In addition, the evidence largely consists of inadmissible hearsay. Kohberger contends, however, that under Chambers versus Mississippi, hearsay tending to establish third-party culpability may be admissible.
Oh, go back up. This is to
go?
protect. Right there. To protect.
Oh, to protect a defendant's constitutional rights to a fair trial and to present a defense under the 6th and 14th Amendments. What Chambers actually held is that an accused has a due process right to the admission of exculpatory hearsay, i.e., a confession by a third party, provided it is accompanied by persuasive assurances of trustworthiness. So you are going off of hearsay, Anne. Okay. So nothing links. Okay. 3 of the individuals were each socially connected to one or more of the victims, interacted with one or more of the victims at social events in the hours prior to the homicide, lived within walking distance of the crime scene, and were familiar with the layout of the victim's home from prior social events. While perhaps this evidence could suggest an opportunity to commit the crime, which no doubt is an opportunity shared by dozens of others in the victim's social circles, there is no compelling evidence that any of them had a motive to kill the victims, much less physically harm them, or a means to do so. Further, there is no evidence connecting them to the crime scene. They have each cooperated with law enforcement, providing DNA samples, fingerprints, and allowing searches as requested. Notably, lab testing has excluded their DNA from samples taken from the crime scene and victims. The 4th individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. Go ahead. What's up?
Okay.
What's cooking?
I'm putting on my tinfoil hat here. Okay. What if? Did you know I have thought for a long time that 4chan, the 4chan stuff could have possibly been Bryan Kohberger trying to point the finger to other people like the fraternity guys? What if they're using some of that? Because they blamed those guys that we saw that were going to be in the Amazon Prime documentary.
That's true.
What if?
You know what? Nothing would surprise me at this point. Anne's really running with, she is admitting in this, there is nothing connecting, but I heard a little birdie say this. Oh, really? As a lawyer, that's a pretty far reach you've got there. She's admitting it's based on nothing but hearsay. So you're bringing up 4 alternative perpetrators and you're trying to meet the standard while at the same time admitting it's all hearsay? And actually, it's only excluded them from being under the victim's fingernail. Like, what?
Well, I think it's good. I think it's good to note that they have, gathered DNA and investigated those people,
Well, of course. But still, like, for Anne to be screaming all this evidence about Kohberger, this, that, nothing, that, but then say, well, I have no evidence linking these 4 alternate perpetrators, but I heard at one point or another something happened.
So then my question is how do you get past Brian's DNA being on the sheath? Like that's like a separate rabbit hole. Because like even, there was something along the lines of in one of the past hearings where Hippler said that even if there was like, say, a multiple party perpetrator, it still didn't preclude Brian and his DNA being found. I just kind of go back to that.
I don't know.
And I'm glad that they're redacting these people because God knows everybody would be diving into this. Like,
no. We're close enough. Keep everyone protected. It says the 4th individual did not know the victims, but had a passing connection to one of them while noticing her shopping at a store approximately 5 weeks prior to the homicides. He followed her briefly out the exit of the store while considering approaching her to talk. He turned away before ever speaking to her. The event was captured on surveillance camera. This individual subsequently cooperated with law enforcement, providing his phone number and a DNA sample. As with the other alleged alternative perpetrators, lab reports excluded his DNA from the samples taken from the crime scene and victims, and there is no evidence connecting him to the crime scene.
Sorry, like, could you imagine this poor guy who was like, I just thought this girl was hot.
Right.
You need my DNA? Okay.
Right. It says the fact that these individuals lived within walking distance to the crime scene is not probative evidence, given that the perpetrator drove a vehicle to the crime scene. Further, none of these individuals drove a vehicle matching the description of the suspected killers. So collectively, Kohberger's proffer with regard to these 4 individuals fails to give rise to even an inference that they committed the crimes or otherwise make it more or less likely that defendant was the perpetrator. Therefore, it is irrelevant under IRE 401. Kohberger has provided no probative, admissible, significant evidence of motive, ill feelings, means, presence at the scene, or any other connection to the crime that could possibly move the ball to the extent it supports an alternate perpetrator theory. And 5 says, at the state's notes, none of the 4 individuals drive a car that could be mistaken for a Hyundai Elantra. So at best, Kohberger's offer of proof can give rise to only wild speculation that is possible any of these 4 individuals could have committed the crimes, which is inadequate under Meister. Again, mere inferences that another person could have committed the crime will most likely not be relevant. So in other words, it is not sufficient for a defendant to merely offer up unsupported speculation that another person may have committed this crime, which is all defendant has done here. So even if there was a shred of probative value in the proffered evidence beyond wild speculation, it is excluded by IRE 403. As the 10th Circuit noted regarding alternate perpetrator evidence, it is not sufficient for a defendant merely to offer up unsupported speculation that another person may have done the crime. Such speculative blaming intensifies the grave risk of jury confusion, and it invites the jury to render its findings based on emotion and prejudice. Likewise, here, presentation of the proffered alternative perpetrator evidence would pose a great threat of confusing the issues because it would force the state to defend against a nebulous allegation that perhaps these individuals were involved. This foray would leave the jury astray, turning its focus away from whether Kohberger, the only person whose actions are on trial, committed the charged crimes. It also presents a threat of unfair prejudice, as it would invite the jury to blame unrepresented persons for a heinous crime when there is not a scintilla of competent evidence connecting them to the crime. Finally, it would do nothing more than waste the precious time of the jury and the court in what is already a scheduled 3-month trial. Nonetheless, the court's ruling does not preclude Kohberger from confronting and cross-examining the state's law enforcement witnesses regarding the thoroughness of investigation, particularly in following up on and ruling out leads generally. Do you want to continue reading?
Yeah, sorry. Where did you leave off? I was responding back.
Indeed. The first sentence, indeed.
Okay. Can I state something real quick though? I have seen rumblings of people, Melissa, having a bit of an issue with the judge stating as fact that like the perpetrator's car is a Hyundai Elantra. I don't know if we want to talk about that later, but there's just people that kind of feel like that's for the jury to decide that fact. I just thought that was kind of interesting.
Yeah.
But anyways, okay, so indeed the Idaho Court of Appeals recently found an unpublished opinion that questioning a detective about failing to follow up on other plausible leads was relevant to alternative perpetrator analysis. We agree with Emerson that a relevant line of inquiry would be to question the scope and breadth of the investigation and to explore on cross-examination whether plausible investigative leads about third parties were ignored or overlooked. It further stated that this line of questioning may not include inquiries about the investigation of specific third parties absent satisfying Meister, noting while evidence challenging the thoroughness and reliability of the investigation might be probative, questioning whether law enforcement investigated specific individuals with no connection to the murder provided no probative evidence. Moreover, with no connection between the evidence and the crime, there is no explanation or justification for the questioning, and it would not help the jury answer the only question in the case, whether Emerson killed James. So that was in their law or case law. So the court will apply these same parameters at trial regarding Kohberger's cross-examination of law enforcement. He may inquire to the reasonableness of the investigation, including investigating and rolling out other leads. He is not, however, permitted to question law enforcement about the investigation of any specific individual as a potential alternate perpetrator without first raising the matter with the court outside the jury's presence. Order. Based on the foregoing, Kohberger's offer of proof regarding alternate perpetrators is denied.
Ooh, what do you think about that?
I mean, it makes sense. Like, I think that in any cases where I've seen them try to bring in alternate perpetrators, there's got to be a sufficient proffer, and the court approved that line of questioning to develop. So I don't think that it's wrong, but I think the stuff I'm probably I'm just it's all the words Hitler had to say was very matter of fact. Like we're at the end of this. Like you see, like I've seen people talk and they're like, how do you know that the state hasn't complied? Like we've seen multiple filings by the defense for request of discovery. And, I had questions about it too, but that's been addressed in other hearings and motions that the state just kept asking for stuff. And then, or sorry, the defense just kept asking for stuff and the state would provide. Like, I think that sometimes, like, when things are sealed and in the cloak of darkness, it leads others to think that maybe the state's not adhering to their rules and deadlines, and that could go vice versa, And I think that it's interesting after all the discovery request, everything provided, that we got this denial on the motion to continue. Like, that's the one I'm most surprised about. But when in regards to the alternate perpetrator, or not surprised about, but like really interested in like the judge's findings, based on his experience with this case. But also the alternate perpetrators, I guess I feel more comfort in that they've have the DNA of the individuals that they are eliciting as alternate perpetrators, have ruled them out. I'm curious as to what Anne and the defense team feel like it's need to move forward on those folks,
Right.
Like, I guess that there's just a gap there. Not that their DNA has to be there, but if they're not any of the unknowns, then I don't know.
I don't know. I just think it's weak, first with the alibi, now even down to the alternate perpetrator. I see her just pulling out any stop she can along the way at this point. But at the same time, demanding, like you said, all of the discovery requests, at the same time complaining because discovery's still coming in. Yet, what? I don't understand.
But it makes me wonder, like, what the defense strategy is going to be. I think we surmised at the beginning it was going to be alibi based on the alibi demands. And then now,
go ahead.
sorry, then this alternate perpetrator stuff popped up in the last few months. And so, I mean, there's always the good old fashioned reasonable doubt, but, some of having certain defense strategies definitely can bolster their case,
I think that obviously she's going to try to do what's within her limits, but I don't just say that. I believe she knows her client is guilty, as she would. She still has to do her job, and I think that is why all of her focus is going on the penalty phase. Like I said earlier, she is aware, so it's not about if he will be convicted. She knows that there's a good chance that he will be convicted, and so her focus is on what to use as a mitigation factor at penalty phase. And because think about it, like that's been the main focus for a while now. I think especially the last 6 months, it's gone to penalty phase. And yeah, she's still gonna be attempting, she's still gonna throw out that alternate perpetrator, right? Because how did it go from the tip line, which that's interesting actually now, because she says we found a potential alternate perpetrator going through the tip line, to now 4, which tells me that maybe they got a tip regarding that stalker, and that went from 1 to then 3 now. But how are you going to do an alternate perpetrator if the 3 are just friends who knew about it? Remember when they went to the vape shop and so, like, what? So just word of mouth, like that Kaylee had a stalker, like to how are they an alternate? Do they fit the standard to even be an alternate perpetrator unless they had involvement? Are you claiming they had involvement?
Well, I mean, I
have a new one aside from Syray, redacted, Miss Redacted. She is trying to come to save the day now.
I think that you get people that consume content, like, okay, my theory about 4chan, say it's the 4chan one. What if somebody reads one of those 4chans and then calls it into the tip line? And
Right.
There's like hearsay of hearsay. So I think that through the tip line, stuff like that could be developed. But it is interesting.
Sorry, I was thinking of WSU mom Kim. And
What?
she claimed that there were 4 of them in the house, didn't she?
Yeah, but I thought what it.
Imagine it was a WSU mom Kim theory.
Oh my lord, I would fall.
Oh no. Hey, do you want to talk to them about this?
Oh yeah. So Jason Jensen, who's a PI, he was out in Moscow searching for the knife, and I
The
saw on Reddit somebody.
knife.
Yeah, I saw on Reddit somebody posted about it. I was like, oh, that's interesting. So I went to his Facebook, checked it out. So over the last week, he took his dog, search dog Lily, and other volunteers, and they went down I-95 trying to find the knife. I just thought that was really interesting, like that people are out there still looking for it.
It
And they're,
is.
mm-hmm.
He wrote, tonight after dark, I drove the path from 1122 King Road, Moscow to the near Blaine cell phone tower by Highway 95. It took me 28 minutes. I now believe this is the route that Bryan Kohberger took after the murders. We will be searching this area where the red arrow is. The route includes Palouse River Road to Lenville Road to Genesee Juliet Road to Blaine Road to Eld Road from Blaine back to Highway 95. And then,
Yeah, like a snapshot of his dog searching.
which I think it's always going to interest me. I don't think they're going to find that knife. But I honestly, to be fair, I think that circumstantial evidence against Kohberger in regard to the purchase of a K-bar sheath and sharpener and the likelihood that they are not going to be able to produce such items, and then searching subsequently after for another, even adding it to the cart a couple times. Yeah, I think that is a pretty, without the actual murder weapon, I think that's pretty close to the best you could have under these circumstances without the weapon.
Right. I mean, I don't think it hurts to look for it. I mean,
No.
we've heard they've never found it, and if you're able to find it, that'd be great. I mean, my opinion is that he would try to hide it or get rid of it quickly. I mean, he had a tendency to be pulled over a lot, so get rid
Yeah.
of it sooner. And I wish
I,
they could find it.
of course. Now, let's jump back for a second. What do you think that expert is trying to claim about Bryan? Do you think dissociative identity disorder? Do you think another mental disorder? Do you think some type of, I can't go with trauma so much in the past because I wouldn't imagine they're searching history like that. If the event happened, it would be pretty, I don't want to say easy, but I could imagine that they'd be finding that easier versus trying to be able to prove something through the past.
I tend to lean that it would be something. I tend to think that if it's something that would be in a mental health disorder, that it would be something that would put him to where he wasn't aware that he committed the crime kind of situation. Oh, interesting, Katrina. But they could do some testing to see if there's been that.
But that's what I find interesting is, and I'm pulling it back up because Hippler's like, all right, this is pure speculation because even all of the evaluations and nothing supports what this lady is saying. Like nothing, absolutely nothing supports it so far.
Right.
Where was it?
Just look for all the redactions.
Okay, so despite having hired a mitigation team 2 years ago, defense counsel contends that recently discovered blank mental issue, like mental ailment, have raised red flags and that Kohberger may have redacted. According to Kohberger's primary mitigation investigator, attorney redacted, her team of 4 have been diligent in their investigation into Kohberger's life history, but there have been redactions. She believes that with time, she will be able to overcome these barriers by redacting. So I want to find the part. So defense counsel is constitutionally required to conduct a thorough, okay, blah, blah, blah. Yes, I remember that part. So the assertion that counsel needs the continuous to conduct an exhaustive and comprehensive dive into Kohberger's life history for additional mitigation evidence overstates the extent of his counsel's constitutional obligations. But wait, where is the part? Because he wrote. Okay, so they have all of these records and interviews. So it is evident from the reports of Kohberger's mitigation experts, Dr. Orr, Dr. Ryan, Dr. Browns, that they developed an expansive understanding of Kohberger's family, his social development history, family history, educational, mental health. Okay, so the experts have rendered several current diagnoses, which again makes me think it's a diagnosis of some sort. Several current diagnoses and identified other diagnoses for which Kohberger met criteria at some point in his life. So despite such an extensive investigation, Kohberger claims additional investigation is warranted to identify, and I think it's going to be another. And that's why he's saying there's no evidence that links that so far. So defendant has not established that such investigation is constitutionally compelled, particularly given the extensive work already completed. Rather, the claim need is based on unqualified speculation by redaction. Kohberger has not offered any declaration by any of his disclosed mitigation experts opining the same. So again, this is specifically for the mitigation experts, which has to do with his mental health. And so none of them opine the same, nor has he pointed to anything in their expert reports that would support Miss Whoever's speculation. So and a continuance is not warranted to chase down mere speculation that potential evidence may exist. So I really think that, but like, what would it be, Shay? They already have ADD, OCD, ASD. They have, what are they going for here? Now you're trying to pull out maybe dissociative identity disorder, DID, something, but there is nothing in the 3 expert reports that even opine to that. What are they going for, Shay?
I guess I'm kind of stuck on the DID one, if that were a possibility.
DID. Yeah, I don't know. But where is this person coming from, Shay? That, you see what I'm saying? She keeps kind of like pulling out the stops, and what, you didn't get what you were looking for from the first 3, so you pull out now a 4th. But Hippler is saying she's not even qualified to make this opinion.
Why would she not be qualified to make that opinion?
Well, it's all redacted, but she's probably not an expert in that field.
Then what do you think that? Because I was assuming it would be a doctor. Do you think it's a mitigation expert then?
Look, whoever's speculation that Kohberger, whatever, is simply that speculation built on circumstantial evidence, and then redactions, conditions, which are currently attributed by his own by his own mitigation experts. Oh, see, they're talking about certain conditions which are currently contributed by his own mitigation experts to his ASD, OCD, and or ADHD, are consistent with childhood trauma. And 5, there is plenty of poverty, both generational and familial. So according to whoever this bitch is, It says, notably missing from their declaration is any indication on how she intends to confirm her suspicions or how long she expects it to take. And Kohberger has been subjected to multiple lengthy interviews by several different experts over 2 years. Based on those expert reports, redacted. And Kohberger's family has likewise been extensively interviewed, and there has been redacted and been no report that redacted. None of Kohberger's redactions have raised the alarm that redacted, despite having the same information that she relies upon. Instead, it's an invitation for a perpetual continuance. So aside from redaction, all of this information has been available and documented in the record for months. Yet again, that Kohberger is now only moving for continuance. But where's the part that he says it's on an open-ended basis with no plan to bring the matter? So counsel's argument that more time is needed to investigate whoever her information is, likewise squarely unsupported. Kohberger has never moved for an extension. Okay. She, who again is not even marginally qualified to opine, believes that there is evidence that whatever, and seeks additional time to unearth it. Her support, which she has not provided to the court. So she, whoever this is not even marginally qualified to opine to what she is putting forth. Yet you want additional time to unearth it? Screw the 3 experts. And there's nothing in that report that even indicates what she's claiming. But you just want based on pure speculation. And this person is not even marginally qualified to opine. They're desperate, Shay.
So I thought about this. Because, they don't have the insanity defense.
Yep.
The only thing they could try to push for would be mental competence, which would push back the trial, right?
No, I think she's focusing, like, again, this is for the penalty phase.
And this, or whatever condition, maybe a form of insanity where maybe they're looking if Bryan is convicted, that maybe he's not in prison, but he's in an institution.
Yeah, that's what I think they're going for. They don't have it. So she is not focusing on being able to, and I don't want to say she's not focusing on being able to prove he didn't do it. Obviously, she's going to put up that fight, but that's why I think all of her focus now is going towards penalty phase and going for some type of, okay, this is why you can't sentence him to death because of these factors, and going for some type of he's not even aware type of deal. I don't know if she's going to go, because I can't imagine even if he's convicted of her changing it to now, oh yeah, he's guilty, versus she's going to use something that you can't sentence him to death because ASD is not qualified under one of those, what was it? The schizophrenia can be, but
Atkins. We're talking about Atkins.
Yes, Atkins.
Which is more lower IQ and
Right.
being knowing of the crime you committed and the implications of it.
Right. And so I
Which
think
they have said already that he has a higher IQ.
Yes. It was social issues, not intellect.
Yeah, I'm really freaking curious.
Well, and who is this? Where did she come from?
Where did you come from?
Who are you?
Could it have been somebody who doesn't have the professional license to be able to make that diagnosis, that there was a theory and now they're trying to see if they can get them to prove it, maybe a childhood school counselor? I don't know. I'm
Probably
just trying
truth and transparency.
What?
It's probably truth and transparency.
Oh my god. Stuff.
Sorry, because that's honestly that's the type of shit I think in my mind when I'm reading Hitler's words saying like you are not at anywhere even marginally qualified to opine to this shit. It is pure speculation. We are now all dumber from having heard it. I'm thinking she's listening too much to these tubers, man. That's what she's doing.
It's probably Kim.
Yeah.
If I had to guess it, you know.
Yeah.
I am curious though, because like it to me it felt like it didn't include the family. Like it had to have been somebody else.
Yeah, no. This is someone who
And
probably
how
isn't,
they got to that.
well, like I said, he's referring to the experts, their reports. So whoever this person is, I would assume could be qualified to speak in general on mental health, but is clearly not qualified to make the jump that they're trying to put forward here.
That's why I think it would have to be like maybe a counselor or something of sort,
Mm-hmm.
like of the past. Like was there a certain event or something they came to them and talked to them about? I'd be really curious.
Well, remember at the last hearing, Anne said that certain doctors won't speak to them, like certain people from the past won't speak to them.
Well, I think that even some of the people that I saw on that witnesses that they were trying to talk to, like what one of them was the owner of the boxing gym that Bryan would box at. You know, there's speculation from people saying like, you know, would the prosecution want to bring him in because it would prove like he didn't have dexterity issues. I think there was students from like a student from DeSales or in another professor from DeSales. But there's people that apparently like they're trying to subpoena them to bring them in. Um, and there's just some people that don't want to be involved in it. And it was part of the mitigation phase. It was in one of those like documents, like kind of buried in there.
I just, it's just very interesting, and just like Ashby saying, it's so weird to fight more against the death penalty than the guilt itself, and that's what's standing out to me. Not that she's focusing on that. Of course, she needs to be focusing on that, but it seems like there is a lot more focus on the penalty phase than there is for the actual trial itself. And I think I know why that is. Think about it, like how weak that fucking alibi was, how weak the alternate perpetrator. You're admitting it is just merely word of mouth, something you heard, nothing connecting it. Actually, there's a bunch of evidence that points against them, but all massive amounts of effort towards that mitigating evidence, mitigating factors for the penalty phase.
I'm
She
so
knows.
curious about all those redactions.
No, Katrina. They stood firm from the beginning. No plea. No deal. They're not offering.
And they'd have to talk to the parents too, out of
Yep.
courtesy of the victims.
They say they have enough 10 times over.
Man,
And honestly, with the recent Dateline, there was a lot in there we didn't know. So, but God only knows how much is about to come out.
I just
God
wonder,
only
like,
knows. Sorry, God.
to be a fly on the. No, I was just thinking, like, to be a fly on the wall, you know? I'm just so curious of like where you would be digging for that. Like now you got my mind like trying to fill in the gaps of like what could be redacted.
They redacted everything regarding her.
And Melissa, that only included the expert Brian's defense. That didn't include the subsequent review that the state was going to get, right?
Yeah.
Like any citation. Okay.
Who is this? And she
Interesting.
clearly was just brought on. Just brought on. What have you been doing, ma'am? This shouldn't be coming out on the heels of trials starting. We've never had redactions like that regarding specifically, but that's how, like, whoever this is, you're coming out the gates making these heavy claims based on nothing. And even all of the experts that have conducted their interviews and evaluated everything, nothing even in any of their expert reports linked to what she's claiming. It's wild speculation, in Judge Hippler's own words, wild speculation. And that's, I think, all they have. I just cannot wait. I cannot, like, to come. It's been years, and to come to the point where we're finally going to hear the evidence against him. But I already know the shit show. Like, it's, people are not going to be satisfied no matter what comes out. Do you think? Shay? Bone? Boop boop badai. Alright. Poop hey. Shay? I mean, he's going to have a life of punishment. I think it's just, here's a mitigating factor of why death penalty should be off the table. She knows. I'm sorry. Like, I respect everyone's opinion, and I understand for the people who think, no, that he can't be guilty. Like, I don't like when people are 100% sold he can't be guilty. The same way he shouldn't be 100% sold he is, because trial hasn't happened yet, but people are so certain that they know all of the evidence against him based on the little bit that we've gotten. It's just crazy. Well, I don't know where she went, but I'm gonna hop off for tonight. I'm so beyond excited for this Amazon. There she is. I'm so beyond excited for this Amazon series. I think it's July 11th. It's right around the corner, and I don't know how many episodes it's going to be.
They said 4-part.
4-part?
Yeah, that's what it said in the material.
I'm worried that they're going to beg for a plea deal now that they're out of options. I just hope the state does. I thought that they were going to already, Harlot. Do you think that they're going to this close? She might. What do you think, Shy?
Think about what?
You think defense is going to come out and ask for a plea?
No.
It's a little close.
I don't think Brian would request that. I really think that I don't think so. I mean, what do you think?
I don't think that he would want to, but I think with Anne, like, what I see through these motions and filings is Anne's out of options. She's out of options, as she would be, you know, if her client's guilty. But it's a matter of what Anne would advise him would be the best course of action. But I think they do have the benefit, because I look at people, and there are people who are 100% sold he ain't guilty. But you know what? I have to remind myself, that's people who followed from the beginning, and there was a lot of conspiracy and speculation. Would a juror who didn't follow have that in their mind? I don't think so. Oh, Allie, Amazon Prime is coming out with oh my God. Here, I'll play it real quick before I go. They're coming out with a series, and Allie, oh my gosh. Like, it has all of the, Hold on.
It's adapted from James Patterson's book that he wrote. And we had heard that the Chapins had signed with Patterson.
Yeah, you're right. We did. Are you ready for this? Oh my God, Allie, I didn't realize you didn't know about this. Ready?
You gotta play
You're
both
going to get
clips.
chills.
These kids were just having the best time of their lives. Nobody could have imagined what was about to happen.
4 University of Idaho students were found murdered in their off-campus residence.
The attack was targeted with a, quote, edged weapon.
I set foot in the house and immediately Hunter was like, get out, somebody call 911.
The question everybody wants answered is why? Why these 4 kids?
This can't be true. I mean, this is Idaho.
That's
Your
Maddie's
kid's supposed to be
friend.
safe, going off to college, having a good time.
We were a big group of friends. Why would you target those 4? There's a big realization that we had been stalked for so many months and had no clue.
People were panicking. People were really fearful.
There's this person out there who had just murdered our brother, and he's still out there somewhere.
Moscow police put out very little information.
Rumors and speculation just started to fill the silence. How could they not tell us what's going on?
Dylan and Bethany were getting blamed.
Completely slandered on the internet.
People were thinking that we were murderers.
We're getting death threats. People always suspect the boyfriend.
Somebody had sent a photo of my house. Now people know my address and saying I have something to do with it.
I got a phone call from the officer. They said that we have a suspect in custody.
I just felt my heartbeat go crazy fast. I know that guy.
My mom said, it's over. And I said, no, Mom, it's just the beginning.
Oh, I got chills, man, all over again. Everyone is in. I'm so eager to watch it.
I am too. And I'm wondering, if they thought that, like, if they were releasing this, like, during, like, when the case is going, it wouldn't cause problems, but it's before it's going, you know?
Yeah. Which, you know, it's whatever timing, not the best, you know, like, but they have their, listen, majority of them have never spoken before. A word. Everyone spoke on this every day for years. They have their right to speak whenever they want, as long as it's not violating the gag order. July 11th on Amazon Prime, midnightly. That's when the first episode drops. I don't know if it drops all at once, all 4 episodes on the 11th or what. Yes, Emily and Hunter spoke out. Hunter breaks my heart because you could tell, you know, it's aged him, you know, as it should, but I have a lot of respect for Hunter. I have a lot of respect for Hunter. And my heart's going to break when we hear his testimony.
I know. It's going to be heartbreaking to hear.
It is. But, all right. I'm going to hop off for tonight. Thank you, lady. I love you. And this is just, I can't believe, Shay, we are about to be July and it'll be next month. Like, trial is next month. We're a little over a month away.
I know. I'm so ready for it.
And the prime is exactly 1 month before the first day of trial.
Wow.
I know.
I'm curious if they'll end up doing a sequestration.
Sequestering the jury. I cannot imagine them not sequestering this jury. I cannot imagine them not sequestering, but who knows? Honestly, I think they need to be sequestered, but that's 3 months. That's a big app. But then I think about OJ. I don't know. But in regard to it being a fair trial, I think they have to sequester.
Yeah, I think it may happen, but it's going to be a nearly 3-month trial. That's a long time.
Yeah, it is. But looking at it in regards to his right to a fair trial, I think sequestering is necessary for this one. Even with just the amount of victims alone, like it's it's too big. I don't know. I guess we'll see. I think Judge Hippler will make the right decision.
Yeah, I mean, I think so too.
And we got additional alternates,
And to get death penalty qualified jurors as well. I mean, that's
Yes.
going to be a whole thing of its own.
Yes, you are right. You're right. Oh man, I can't wait. Like, and I don't mean that, again, it's hard to say that because you're not trying to say excited, but I'm excited for answers, for justice, for clarity. I'm excited to see the court process and to see how the state presents its case and how defense presents its case. I'm very eager to watch all of it.
Oh, I know. Me too. I'm so curious what all we're going to find out. And I'm just hopeful for justice and a fair trial.
Yes, absolutely. All right, love. I will talk to you soon. Thank you, everyone, and thank you, mods in chat. I want you guys to have an amazing rest of your Saturday night. And I will see you guys all soon. Good night, Shay.
Good night. Bye.
Bye. Should we Kimball roll out of here? I think we should.